Welcome back to the deep dive. We are going straight into one of the trickiest, most foundational issues in criminal law, how the law actually decides if a person is responsible for a crime when their mental capacity is really in question. This deep dive is tailored for you, the learner, so you can walk away with a clear step-by-step model of the Model Penal Code, the MPC standards that govern this critical determination.
Right. Our mission today is really analytical clarity. We're looking at the architecture of legal responsibility. We will break down the MPC's definition of the insanity defense, the one in Section 4.01, articulate its precise elements, and then kind of model the complex analysis needed to apply it. And crucially, we'll also examine the important difference between being legally irresponsible and maybe just having diminished capacity, plus the separate issue of fitness to stand trial. It's a lot to cover.
Okay, let's start right at the very top then. When we talk about excluding criminal responsibility because of a mental condition, what's the central foundational rule under the MPC? And why is this rule seen as such a big shift from older legal standards?
Okay, the central rule is MPC, Section 4.011. It sets up this dual test, essentially. A person is not responsible for criminal conduct if, at the time of that conduct, as a result of mental disease or defect, they lack substantial capacity. And here's the key part. Either A, to appreciate the wrongfulness of the conduct, or B, to conform their conduct to the requirements of law.
That distinction, the either structure, that's really key, isn't it?
Oh, absolutely. That's the sort of revolutionary part. The MPC test explicitly recognizes two separate paths to non-responsibility. So Clause A, the ability to appreciate wrongfulness, that's the cognitive prong. It's a bit like the old M'Naghten rule, focusing on whether the defendant knew what they were doing was wrong.
Yeah.
But Clause B, the capacity to conform conduct, that's the volitional prong. This recognizes that someone might intellectually know an act is wrong, but still be, unable to control the impulse because of their mental condition. That's why the MPC standard is just much broader than what came before.
So if we look at that 4.01 definition, can we break it down into, say, 4 distinct elements that a defense would need to show?
Precisely. Yeah, 4 key things. To meet the standard, a defendant has to show: 1, the conduct happened at the time they were suffering from the qualifying mental condition. 2, the condition itself qualifies as a mental disease or defect, and we need to immediately talk about the 4.01 exclusion there. 3, the condition resulted in a lack of substantial capacity. It doesn't have to be a total inability, just insubstantial. That word matters. And 4, this lack of capacity affected either their appreciation of wrongfulness or their ability to conform their conduct to the law, one or the other.
Okay, before we apply this, you mentioned that crucial exclusion, Section 4.012. It seems designed to stop a certain kind of argument from working automatically. What exactly does the MPC exclude from being called a mental disease or defect?
Right, subsection 2. It excludes an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The policy thinking here is pretty critical. The MPC drafters didn't want conditions like, say, sociopathy or psychopathy, or defined solely by a history of crime, to automatically give someone an insanity defense. The defense has to be rooted in some underlying pathology, not just a lifelong pattern of bad behavior. Now, if the condition has other clinical symptoms besides just the antisocial conduct, then the defense isn't automatically barred.
Understood. So the law's looking for a diagnosed illness, essentially, not just persistent offending. Okay, let's model this rule, because the complexity, especially around substantial capacity, really only clicks when you apply it. Let's use a hypothetical scenario to walk through this element by element. So the defendant is charged with battery, attacked his landlord. The defense claims non-responsibility under 4.01. Now, the evidence shows the defendant suffers from severe, persistent paranoid schizophrenia. And this isn't just a label, it's shown through clinical delusions. He attacked the landlord because he genuinely believed the landlord was a sentient machine sent by a foreign government to steal his thoughts through the electrical wiring. Pretty specific delusion there. Okay, let's start the figure-out analysis. First, what are the key details, the legally dispositive facts that the defense would really hang their hat on?
Okay, the essential facts are: 1, the recognized severe mental condition, that's the paranoid schizophrenia diagnosis. And 2, the profound, very specific delusion, believing the victim wasn't even human, but a sentient machine posing this immediate mind-stealing threat. The attack, the battery, was basically an attempt to stop this perceived threat.
Right. And based on those facts, what's the core legal issue the court has to wrestle with here?
The issue is whether, as a direct result of that qualifying mental disease or defect, the defendant lacked the substantial capacity required under MPC Section 4.011. Specifically, did he lack it either to appreciate the wrongfulness of attacking his landlord or to conform his behavior to the law against battery?
Okay. And what rule of law is the court applying? Can you just restate the rule and maybe list out those elements again quickly so we have them fresh in mind?
Sure. The rule is MPC Section 4.011. A person isn't responsible if, at the time of the conduct, due to mental disease or defect, he lacks substantial capacity either to appreciate wrongfulness or to conform conduct to the law. And those elements we're testing are 1. Timing, 2. Qualifying disease defect, considering 4.012, 3. Substantial lack of capacity, and 4. That lack affects either appreciation or conformity.
Perfect. Thank you. Now for the court's elemental analysis, let's really walk through this step by step. How would the court apply the first element? Does this condition count as a qualifying mental disease or defect, keeping that 4.012 exclusion in mind?
Okay, element 1. The issue here is classification, isn't it? Schizophrenia, especially when it shows up with these profound clinical delusions, well, that clearly fits the general understanding of a mental disease. And crucially, it's manifested by symptoms, the complex delusional belief system that go well beyond just a history of crime or antisocial acts. So it's not barred by the 4.012 exclusion. Element 1 is likely met here.
Yeah. Understood. The condition itself qualifies. Now, let's move to the second element. The lack of substantial capacity to appreciate the wrongfulness of his conduct. This is that cognitive prong. How does the delusion play into this?
Right, the cognitive part. The court has to look at the defendant's subjective reality at that moment. Given this really severe delusion that he was fighting a sentient machine trying to steal his thoughts, you'd argue he fundamentally failed to grasp the significance of his actions as wrongful in the way society understands it. I mean, in his mind, he was acting in self-defense against a dangerous, non-human thing. If his perception of reality is that warped, his capacity to appreciate the act as a wrongful battery against another person is, well, it's arguably insubstantial. So this cognitive element looks like it's met too.
And because this is an OR test, meeting that cognitive prong is actually enough to satisfy the standard, right?
That's correct. Once one prong is met, the test is satisfied.
But just for the sake of modeling the whole rule, let's look at the third element anyway. The lack of substantial capacity to conform his conduct to the requirements of law. This is the volitional prong, the irresistible impulse idea. This part often makes courts a bit nervous, doesn't it? How does the MPC try to keep this from becoming a loophole for any impulsive crime?
Yeah, that's always the challenge with the volitional test. The MPC tries to constrain it by requiring the lack of control to be a result of the underlying mental disease or defect. It can't just be poor judgment or bad temper or general impulsivity. So in our hypothetical, even if, maybe, the defendant had some intellectual awareness that hitting landlords is technically illegal, the extreme pressure and fear coming from that core delusion that his mind was under attack might have genuinely caused a complete breakdown in his ability to control his actions. If the delusion created a compulsion so overwhelming he couldn't stop himself, then this element, insubstantial capacity to conform conduct, could also be met. But it really requires strong medical evidence linking the compulsion directly back to the defect.
Okay, so after analyzing all the elements, and especially given the strong evidence for the appreciation prong based on that very specific delusion, what would be the court's final conclusion in this hypothetical scenario?
Based on the evidence presented, the qualifying mental disease leading directly to an inability to appreciate the wrongfulness of the conduct, the court would almost certainly conclude that the defendant is not responsible for the criminal conduct under MPC Section 4.01.
That modeling really clarifies the standard for complete non-responsibility. But, as we've said, 4.01 sets a really high bar. What happens if the defendant's mental condition is, less severe, maybe not enough to completely clear that high 4.01 hurdle? The evidence about their mental state isn't just tossed out, right? That's where Section 4.02 comes in.
Exactly. The evidence isn't useless. Section 4.02 deals with the admissibility of mental health evidence, even when the full insanity defense isn't met or isn't being pursued. Subsection 4.02 is key here.
Okay, so how does 4.021 let that mental health evidence into the case?
This is often called diminished capacity, although the MPC frames it more precisely as relevant evidence for mens rea, the required mental state for the crime. Subsection 1 basically says that evidence of a mental disease or defect is admissible whenever it's relevant to prove that the defendant did, or more likely, did not have the specific state of mind required as an element of the offense. So if the crime requires purpose or knowledge, say for first-degree murder, and the defendant's mental condition meant they couldn't actually form that specific purpose, the evidence comes in to negate that element. It doesn't excuse the crime entirely, but it might knock the charge down to something lesser that requires a less specific mental state, like recklessness.
Got it. So it can potentially reduce the severity of the conviction. Now, Section 4.02 is a bit different. It's often bracketed in the MPC, suggesting states can choose whether to adopt it. And it seems aimed at a very specific, very serious context capital cases. How does it allow mental health evidence to be used differently, specifically during sentencing?
Right, 4.022 is mainly for death penalty jurisdictions. It allows evidence of a mental disease or defect that caused a less severe impairment of capacity, meaning an impairment that doesn't meet the high bar of the 4.01 insanity defense, to still be admissible, but specifically in favor of a sentence of imprisonment rather than death. It functions as a statutory mitigating factor. It allows the defense to argue to the jury or judge that, look, even though this person is legally responsible for the crime, their mental conditions significantly reduce their capacity compared to an average person, and therefore, mercy is warranted in sentencing. Death isn't appropriate here.
Okay, that makes sense. It shifts the focus from guilt innocence to the appropriate punishment. Now let's switch gears slightly to procedural stuff. Section 4.03 deals with the logistics of actually using the insanity defense. What's the basic status of this Section 4.01 defense in court, and what does the defendant have to do procedurally to raise it?
Okay, procedure. Section 4.0361 establishes that non-responsibility based on mental disease or defect is an affirmative defense. What that means, practically, is that the defendant has the initial burden of production they have to notify the court and prosecution and introduce some evidence supporting the defense. Once they do that, though, in most places following the MPC approach, the burden of proof shifts back to the prosecution to disprove the defense beyond a reasonable doubt. And crucially, 4.032 mandates that the defendant must file written notice of their intent to rely on the defense. Usually this has to happen pretty early on, like at the arraignment or shortly after, to prevent trial by ambush.
Right, no surprises.
No.
Okay, one last piece from the MPC's mental capacity sections. Section 4.04. This addresses something completely different from responsibility for the past act, right? It's about fitness to proceed now. What capacity does someone need to be considered fit to proceed with the trial?
Exactly. This is about competency to stand trial, a totally separate concept from the insanity defense. Section 4.04 lays out the standard. It says a person cannot be tried, convicted, or sentenced if, as a result of mental disease or defect, they lack capacity to understand the proceedings against him or to assist in his own defense. So, can the defendant understand the charges? Do they know what a judge does, what a prosecutor does, what their own lawyer does? And critically, can they rationally communicate with their lawyer to help prepare a defense? If the answer to those is no due to a mental condition, the trial has to stop until competency is restored, if possible. It's about ensuring a fair process now, whereas 4.01 is about responsibility for the crime then.
This has been a really thorough, structured deep dive. We've hit 4 key sections of the MPC, each dealing with a different facet of mental capacity in the law. To really help consolidate this for the learner, could you synthesize all these rules we've covered into, like an actionable, step-by-step diagnostic checklist, something you could use for issue spotting or structuring an analysis?
Absolutely. Yeah, pulling it all together into a checklist is a great idea. When you encounter a scenario involving a defendant's mental state under the MPC, here's a logical way to approach it. 1. Fitness to proceed. Competency check. First things first, always check MPC, Section 4.04. Does the defendant currently lack the capacity to understand the court proceedings or assist counsel in their defense? If yes, everything stops right there. The trial cannot proceed until competency is addressed. 2. Affirmative defense status and notice. If they are competent and an insanity defense seems possible, remember it's an affirmative defense under MPC Section 4.03, this means the defense has to raise it, usually with written notice. Then typically the prosecution has to disprove it beyond a reasonable doubt. 3. The insanity test, MPC Section 4.01, assessing non-responsibility. Now you get to the core test for the act itself. Ask A, is the condition a qualifying mental disease or defect? And critically, is it something more than just repeated antisocial conduct? That's the 4.012 check. B, did this condition cause a lack of substantial capacity at the time of the crime? Remember, not total, just substantial. C, if yes to substantial lack, did that lack impair either the capacity to appreciate wrongfulness, the cognitive prong, or the capacity to conform conduct to the law, the volitional prong? C1. 4, diminished capacity, mens rea relevance. If insanity fails, okay, what if the full insanity test under 4.01 is not met? Don't stop there. Check MPC Section 4.02. Is the evidence about the mental condition still relevant to argue the defendant didn't have the specific mens rea, the particular mental state like purpose or knowledge required by the definition of the crime charged? This could lead to conviction for a lesser offense.
That diagnostic checklist is fantastic. It really maps out the whole analytical pathway we've discussed. You now have a clear process for tackling these complex MPC statutes dealing with non-responsibility and how mental health evidence fits into the picture.
Yeah, understanding that sort of nested structure, how these sections interact, is really the key. The MPC, deliberately tried to create a more nuanced system than just did they know right from wrong. It brought in that volitional piece, recognizing that severe mental illness can impact control just as much as understanding.
So what does this all mean for you, the learner? It means you now grasp the crucial distinctions, the difference between being unfit for trial right now and being found legally not responsible for the crime itself. And you see how mental health evidence can play different roles, maybe negating intent or even mitigating punishment.
And maybe the provocative thought to leave you with is this. This Section 4.02 explicitly allows mental impairment evidence, even if it doesn't meet the insanity standard, to argue against the death penalty, suggesting a kind of mitigated responsibility in the most serious cases. So the question becomes, should that same principle apply more broadly? Should evidence of significant mental impairment, even if not legally excusing, routinely be considered to lessen punishment for other serious non-capital felonies? Where exactly should the law draw that line between complete non-responsibility and simply reduced culpability? That's a debate that's still very much alive.